and welcome to Duty of Candor to the Court, Epic Games, and One Bite at the Apple. I'm Samantha Seves, and I'm one of the membership committee chairs of the barrister section of the Beverly Hills Bar Association. And I am delighted to introduce today's speakers today, Dr. Wendy Patrick and David C. Carr. Dr. Patrick is a career prosecutor who has completed over 170 trials and was named California Public Lawyer of the Year by Chief Justice of the California Supreme Court. She has also been recognized among the state's top professional responsibility and criminal attorneys and was honored as Instructor of the Year by the California District Attorneys Association. In addition to her legal work, Dr. Patrick owns Black Swan Verdicts, where she teaches and consults globally on legal, ethical, and psychological topics. Mr. Carr is an attorney based in Tucson, Arizona, specializing in legal ethics, discipline defense, and attorney licensing. He previously served as a discipline prosecutor and manager at the State Bar of California before returning to private practice in 2001. Mr. Carr is active in several professional organizations and is licensed to practice in California, Texas, and New Mexico. Now, let's get started.
All right. Thank you so much for that great introduction. I'm going to share my screen and we're going to hopefully have some fun here because I happen to think legal ethics is one of the most exciting topics that we teach. And I think we're going to try to prove it to you during the course of this next hour. All right. So as soon as I can figure out how to start the program here, let's see. Slideshow. Let's see if this works.
Yeah,
All right.
slideshow should do it.
There we go. All right. So, one of the things that David and I share is a love of talking about legal ethics, all of the different dilemmas and different kinds of questions that come up. I mean, it's one of the most fascinating topics that you can teach on, and it permeates everything we do as lawyers. And I would say everything we do in our personal lives as well, which is another one of my programs. But what we're going to talk about today is a very relevant line of let's say line of cases because there are lots of different cases that get creative when it comes to sanctioning for violations of duty of candor to the court, and that has to do with the kind of case file that was present in Epic Games versus Apple. And when I say case file, I mean the record of what happened, the record of non-compliance with a court order and how that intersects with the duty of candor rules that we know and love here in California. It's a wonderful thing to be familiar with the duty of candor to begin with. And one of the trajectories that we've seen as a legal ethics community, I would say over the last 15 years that David and I have been really doing a lot of these programs, he probably a lot longer, is just that, is that it's been a trajectory. There are more creative ways that lawyers are being called out for violating the duty of candor. It's not just affirmative misrepresentations. It's the more subtle, the more malicious, the more devious. Those are court's words, not mine. That characterize some of what we see in some of the rulings at issue, and that's going to include a little bit about what we're going to be talking about the ruling in the Apple case today. And to give a foundation for what we're going to be talking about, I like to think of it as candor inside and outside of the courtroom because we in California, and this is common in some other states as well, we have a variety of ways that lawyers manage to violate the duty of candor. It's not just candor when speaking in court. It can be a violation of truthfulness in negotiations. It can be misrepresentations in pleadings. It can be affirmative, I'll call it miscalculations or creative ways to say that you're following a court order when actually you're sidestepping the rationale behind the court ordering whatever it was you were supposed to do in the first place. And that we're going to see that with respect to the Apple case in just a minute. But candor is becoming an ever expanding duty of a lawyer. I also have to say, you heard that David is a former state bar prosecutor. What a great platform for him to be able to sort of work in some of the trends that perhaps he's seen over the years in the variety of ways that a lawyer's candor can either be an aggravant or a mitigant in state bar proceedings. So, for a variety of reasons, the duty of candor is one of the most important duties that lawyers have. Cutting corners doesn't cut it. when it comes to state bar prosecutions and discipline. And that is ever so true today, perhaps even more so in years past. And I say that knowing that no doubt plenty of my Los Angeles based colleagues may actually be on the call. Who could probably trade places with me in a second and just pick it up and give the rest of the program. David could as well. So I'm sure I'll get emails after the fact if we do or say anything that they can relate to because it's really a great topic. Okay, I'm going to turn it over to David for this. I'm a career prosecutor. I also have a PhD in theology. That's why I'm often called Dr. Patrick. But the process of getting the PhD in theology really made me appreciate all the work and trouble we go through in learning how to not only be lawyers, but how to be ethical lawyers, given the continually changing legal landscape. And with that wind up, David, take it away and let us know a little bit about Epic Games versus Apple.
Well, thanks, Wendy. I appreciate the kind introduction. Let me just, as a sort of the preliminary matter, talk about the duty of candor and contrast it with the duty to be honest. There are actually two concepts at play that are related, which is honesty. And honesty in California, I think we have a slide on this down the road, is typically, at least in the state bar context, prosecuted through Business and Professions Code Section 6106, which says that an act of corruption, dishonesty, or moral turpitude is a cause for disbarment or suspension. So we have an actual statutory duty of honesty, which to some degree is replicated in I call them new rules of professional conduct. They're new, I guess, from 2018, still fairly new. But we also have a different duty, which is found in the Business and Professions Code, Section 6068D, which is basically is a duty of candor. And the distinction is important because candor is actually the way candor is often defined, and I think specifically defined by the Office of Admissions, for the State Bar of California, and in the admissions context, the duty of candor is the quality of being so forthcoming, of being open, of revealing information that you may not even have a duty that you may not even have a duty to disclose. Candor is a quality in many ways. It is much more than being honest. Honesty is important, but to be prosecuted for a dishonest act, you have to have an intent to deceive. Candor is actually a more expansive duty than the duty of honesty. So that's an important distinction. And I know it's an important distinction because when courts are, and you see this is something you see in the Epic versus Apple decision. It's more than being honest. The court wants you to be forthcoming. The court wants you to give the court information and not play silly games concealing information or standing on legalisms to say, well, this is the fact, this is not a fact, this is privilege, this is not privilege. The court, and I think you see this in Epic Games, maybe you see this even more in federal court in state court, though, every judge wants you to be candid. Every judge wants you to be more than honest. Every judge wants you to tell the judge what's really going on here and not hide behind, silly games. And it's funny, this decision is called Epic Games, and when you read Epic Games, you get the feeling that Apple was playing its own epic game of trying to deceive the court by finding too clever by half ways around this injunction. So, Epic Games versus Apple is a pretty interesting decision. It's kind of a disheartening decision. Uh, and the thing that struck me about Epic Games was that the the magistrate judge, in her decision, I think April 30 decision, where she referred the matter to for possible criminal contempt prosecution, the judge really took Apple to task for this incredibly elaborate pattern of conduct, a pattern that was quite apparent in the evidence of trying to work around the court's previous injunction. And the thing I guess that strikes me as a lawyer who represents other lawyers is the extent to which the lawyers emerged somewhat unscathed in the decision. Apple was put on the carpet for a lot of behavior, but the lawyers essentially were not referred for discipline. The lawyers weren't even mentioned in the decision, which I found very interesting. There's a line where they reference the fact that although lies were told, the lawyers took no remedial measures to correct the lies. So the thing about Epic Games that's interesting to me is that the lawyers essentially emerged relatively unscathed in the decision, which I found interesting.
And you see on the screen about sort of a little bit about the highlights of the decision. And I've got one more that David kind of talked about this. And I'm going to pick up on what a really great point that David made. So we may not be the ones, the lawyers, may not be the ones engaging in dishonesty, game playing, whatever it is. Misrepresentation is what we often say because it's possible to be technically correct and completely misleading in context.
Yes.
David and I often teach on ethical advertising, and we talk a lot about that. But the duty of candor in court 3.3 includes a duty to clean it up. If you know something got out there and you know it's not true, take remedial measures. And I have to say, our new California rules that we adopted in 2018 take a very expansive approach as to what that means. And I always say, you look at the rule 3.3, duty of candor. Most people have it memorized. Don't cheat yourself by not looking at the comments because we have more comment sections today in the new rules. I say new since 2018 than ever before. And I will also remind everybody that not all of those rules are dated back to 2018. Several of them have been revised as recently as last year. It used to be like the phone book. You got an entry in there or an ad or whatever it was. And if it was incorrect, you had to wait till the next year. That is not true anymore anywhere. And it's also the case with ethical rules. Ethical rules are revised frequently. One stunning example of that is artificial intelligence rule competence 1.1. But that's just one of many example as to why you can't just print out the ethics rules, put them in a binder and put them on your shelf. They have to be a living document and you have to look and make sure that they haven't been updated. Oftentimes when they are, they come with accompanying case law that justifies the update. So that's one of the ways in which you can comply with 1.1 competence.
I just have to comment, Wendy, that that is such an important point that you have to work to keep up with the ethics rules. Even the ethics experts have to work to keep up with the ethics rules. You can't rely on what you learned in law school. The thing you learned in law school, I mean, what I learned in law school goes back so far, I don't even want to talk about it. But it goes way back, actually all the way back to the old Model Code of Professional Responsibility with the ECs and the DRs, which is sounds like it's the Stone Age now. You can't rely on what you learned in law school. Hopefully, you had a good PR course in law school, your ethics knowledge has to be a living, breathing, ongoing uh, process. One of my favorite California cases says a lawyer has a constant and perpetual rendezvous with ethics. And that's what Wendy was talking about when she says ethics pervades everything we do as lawyers and even lawyers in our personal lives. That is literally true. And I always try to work to instill that attitude in lawyers that, you, you, the State Bar of California says, well, you get to spend 4 hours every 3 years learning about legal ethics. Of course, if I had my way, it'd be a lot more, and it's really disheartening to see good lawyers get into trouble out of sheer ignorance. So
Mm.
don't be that lawyer.
Yeah, no, that's a really good point. And you know what? That's a great segue into a discussion of the California rules, illustrated with a photo I took, not from the internet, out in Palm Desert. But part of why I love photography in California is we are so unique in so many different ways, and beauty and geography are some of them, but the ethics rules are another. And we are tough in California when it comes to looking at violations, when it comes to taking the duty of candor type violations more seriously then perhaps it would be taken elsewhere. And this ruling we're talking about today really illustrates that fact. I'm a career prosecutor, and one of the trends that we began to see gosh, like, as long as maybe 20 years ago in the readiness departments was, and if we were doing this live, I would see if anybody in the audience would guess this. The one question courts complained more about than anything else is, are you blank? And the answer is ready, because the same is true in civil courts. The worst thing lawyers were doing is answering up ready when they technically didn't know whether or not everybody was served. Discovery was complete, the negotiation process. And what they were doing is tying up courts' precious time with cases that really weren't ready. So that became a candor issue. And David would say, this goes to, is it honest not to full disclosure as to the facts one way or another? And so it would probably be preferable asked questions like that if lawyers explained, this part is ready, this part isn't. Do you want me to check on this? In other words, this full portrait of whether or not you actually are ready to get sent to a department. So too with complying with court orders, which of course was one of the bases of the recommended sanctions in the Apple case. Is court orders are meant to be obeyed. Like that mug that says she is meant to be obeyed, or your parents are meant to be obeyed. I've seen it a lot of different ways. Court orders are meant to be obeyed. There was a great line in the Apple decision about a court order is an order, not opening negotiation. So that is one of the things that we'll probably see again. But I want to say one of my favorite parts. I know, right? Wendy, get a life. One of my favorite parts of the our rules here in California is this. It is Rule 1.0, Comment 4. Why? Because it illustrates very nicely how our rules really advise us and suggest and invite us to look elsewhere for guidance if we can't find the answer we need in California. Which, by the way, for many of my ethicists on the line, that happens more often than not. The California rules just don't cover everything that rules in other states do. And if they do, they cover it a little bit differently. By the way, that really applies to our latest acquisition, 8.3, the snitch rule. We really did, our snitch rule really looks very different than the ABA or other states. So, a little caveat. But look at what it says here in comment 4. In addition to the authorities identified in this rule, we are looking also at opinions of ethics committees. So, for example, David and I sat for years, I think you still are, on the San Diego County Bar Ethics Committee. We both chaired it. I'm a former chair of COPRAC. I think David spent his time on COPRAC also. But
Yeah.
we spent all this time writing ethics opinions to try to give factual support in hypothetical form for practitioners so that they never do get that letter from the state bar. Look what else comment 4 says. Ethics opinions, rules, and standards by other jurisdictions and bar associations, emphasis mine, may also be considered. Some of you may be old enough to remember Google Ethics. We used to have these like special Google browsers that we could use to find different topics. Now it's just a regular search, or I don't know. I'm sure a lot of you are doing it on ChatGPT or Westlaw, and then of course backing it up with reading the cases. But it's a great disclaimer we have in our own rules that you're invited to look elsewhere. Now, David also testifies as an expert witness in ethics, and what he would probably say is this is part of a standard of care nowadays, is that lawyers are expected to know that they don't just stop their search in the state where they're licensed, because the state bar is looking at other jurisdictions. If we don't have what we need here, so should we. And if you look at the comment sections at many of our own state bar and our own professional rules here in California, you will see other jurisdictions and guidelines cited right in our own annotations, right in the comments. You'll see references to the ABA standards. You'll see references to other standards. And that's important to understand how expansive our rules are. Hey, David, anything before I move on?
Well, there's an important point here for practitioners in federal court. Is that the rules of professional conduct of the State Bar of California are binding in California courts. Now, when it comes to the federal courts, though, there's a little more latitude that federal judges have. And take a look in most federal local rules, usually around a local rule 83.3 or dash 3. you'll see a discussion of what standards are binding in this federal district court. And you'll see that generally speaking, well, you see language much like this. They'll say, generally speaking, the rules of professional conduct and the standards of the State Bar of California are the standards of conduct in this court, but they're not the exclusive standards in federal court. Federal judges, being separate sovereigns, have more discretion to pick and choose between the rules they like. And honestly, many of them like the ABA model rule formulation of Rule 3.3. I did a panel about 15 years ago with a magistrate judge. We were talking about a model rule 3.3 versus California's. Actually, California had not adopted 3.3 at this point. The ABA model rules are much different than California because they contain much more robust exceptions to confidentiality. And the ABA version of model rule actually gives a lawyer permission as part of remedial measures to correct past perjury or dishonesty. Gives the lawyer permission to disclose information to the court that's not present in California. So in federal court, in state court, we have California's very strict confidentiality rules, which make our rules of professional conduct different. In federal court, it's a little bit more open. And I'll tell you, the federal, and keeping with that candor concept, the federal magistrate judge really likes the rule that says you got to talk. You got to talk about stuff that you might not be able to disclose in California, and that's often an ethical issue. Is the federal judge wants me to disclose confidential information? Can I do that? And it's a tricky question because the rules are a little bit different in federal court.
That is one of the most fascinating questions we've discussed over the years is what do you do when you're not technically following at all times our California version, which of course highlights the duty of confidentiality above candor to the court. And we've actually written an ethics opinion on that in San Diego. It's a fascinating question. I know some of you on the call probably have discussed it with us at some of these ethics symposiums, and maybe someday we'll get a ruling and an answer as to how we do that. But let's go through the main rule that we're always talking about and see exactly how it's phrased here in California. So it talks about knowingly make a false statement of fact or law. Now we have all unknowingly misstated fact. It just happens. Maybe you didn't shepherdize a case or you didn't you misspoke. I mean, there's so many different things that happen in court. Maybe a witness is expected to make certain statements. So you make an offer of proof, and then there's a big oops moment. That is not a knowing violation of 3.3. Now, it might be a violation of 1.1 competence. So you don't want to default into either statute if you can help it. But this is for knowingly making false statements of fact or law to a court. And here's what we were talking about earlier, or failing to correct them. Now, what's interesting about showing you this rule in a conversation about the Epic Games case versus Apple is that the court affirmatively stated that somebody had lied. Now, that's very different than saying, well, first you said this, then you said this. To call something an affirmative lie insinuates you are basing it on evidence that's in the record sufficiently credible that you're going to make that statement. It reminds me of, again, the way 8.3 is phrased, the snitch rule. You have to have that level of corroboration where you have confidence in what you're saying. And this judge's order led us to believe she had that kind of confidence. So that is the way it is phrased in the first statement. And then here is where I think many lawyers probably find themselves in trouble sometimes unknowingly. There's a lot of, and there's probably less so nowadays, now that really the courts and state bars are really cracking down. I mean, motions have to be really good, shepherdized, updated up till the minute that you present that in court. If a law clerk does it, you have to read every case. I mean, we really have to be careful that we don't accidentally fail to disclose controlling legal authority. And we also have to make sure we don't offer false evidence, but it has to be known to be false. Now, one thing about this prong that I'll take a second to discuss, the case law on this issue is a higher standard than some people believe. Some lawyers worry that, well, I really believe that it's reasonable. My client said it. I feel like it's corroborated. That's very different than it making a statement that really doesn't make much sense to anybody. And there's an argument out there that, well, anybody would know that that should have been corroborated before it was affirmatively stated to the court. Same thing with negotiations. 4.1 talks about truthfulness in negotiations, and then we'll get to 6106 as well. But courts seem to have less patience for statements recklessly made that maybe arguably don't even seem like anybody would find them believable without doing due diligence and actually having sufficient proof on which to base those statements. But having said all of that, it is hard to find. Maybe somebody on the call has found it, so please email Dave and I afterwards. Case law um, that is really clear as to what the quantum of proof is to be guilty of offering evidence known to be false. Now, the easy example is your client tells you it's false and you offer it anyway. You don't ever have that. Okay, lawyers don't go out and knowingly commit perjury for the most part. It's that gray area we worry about where maybe we feel uneasy representing it because there's something gnawing at us that makes us think, we should do something to corroborate this evidence before we just enter into the evidence and vouch for it if we really don't know. And it's also interesting, and I'm going to toss it to David for his commentary after I do this slide. That candor in the courtroom doesn't just mean a regular courtroom you're sent to with a bailiff and a pitcher of water and those little paper cups. No, it also governs proceedings, including ancillary proceedings. And they give the example of a deposition. I can't tell you over the years how many lawyers have said, well, that didn't happen in court. That happened in the deposition. Well, guess what? Right there in comment number one, deposition conducted pursuant to a court's authority. And then, of course, tribunal is one of those fancy words that's defined. But this whole process, I'd love to hear, David, it may even call to mind some other illustrative examples of how expansive duty of candor to the court now really is.
Well, I think of the recent cases that have come out about lawyers, and this is something, yeah, again, dating myself. We used to go into a room with a court reporter, and everybody was in a room, and hopefully the room had a lot of hot coffee ready for consumption. And we take a deposition in a room. Now often take depositions via Zoom or video platform. And there've been a number of cases lately, and I actually had a discipline case not too long ago. I guess I can talk about it because it's over now, where a lawyer was essentially taking advantage of the video format to coach the witness. We've had a number of stories in the paper about lawyers coaching the witness, including one story where the lawyer was texting the witness during the deposition while the remote deposition was going on, and basically telling the witness what to say, which I think is a violation of 3.3. Candor to the court includes candor in a deposition, and coaching the witness. In my case, the lawyer was actually doing it verbally during the deposition. But we've had situations where lawyers, again, unscrupulous, dishonest lawyers, in my view, and the view of the court, and probably the state bar, doing things like texting witnesses during depositions and telling them what to say. That's a violation of 3.3. That is a lack of candor, and probably a dishonest conduct as well.
Yeah, those are some really good examples. And I like the way you said texting because, it's easier to text, but somebody's going to see it and it's going to be easier to prove as well.
Well, that's why on the Zoom call, they kept noticing that the lawyer would be looking down, and at the same time, the witness would be looking down at the off-camera phone, which is how opposing counsel said, wait a second. How come they're both like looking down, like they're looking at something else? And that's kind of how it came to light. Although the lawyer denied it, it was pretty clear that that was going on.
Called circumstantial evidence. No, that's a great example. Very
Yeah.
good. So here's an interesting part of 3.3A3 regarding remedial measures. So we talked about knowingly offering evidence known to be false. But one thing that is sometimes overlooked is lawyers will say, well, that wasn't my client, that was just a witness. And so I don't know what the witness said, and I don't have a duty there, but you do. Reading all the way through 3.3 sometimes fascinates lawyers that are used to, the old codes and just kind of common sense approaches they would describe it as to where the duty of candor ends. But look at this, or a witness called by the lawyer. Now, the material evidence may come out in cross examination, but that doesn't matter according to the rule. It doesn't say that. It talks about coming to know about the falsity and take the duty to take remedial measures, including, if necessary, disclosure to the court, unless, and here's where we get our business and profession code section 6068 coming back into play, the confidentiality provision under E, that takes precedence over candor to the court in California. It's hard to even get that sentence out because it doesn't make sense to anybody that practices in another state or under the ABA because it's different in California. So, and courts, I'm sure, are not pleased about the fact that it's under 6068 subdivision E that elevates that duty as paramount. So we had that before we adopted the new set of rules in 2018, and many predicted we were going to do away with it and become more consistent with the ABA in the other states, but we didn't. That's the only in California side of us, is that we retained that chronology of loyalty under California rules.
Well,
Okay.
I just have to
Yes.
say
Oh, absolutely.
that statutory law was written in 1847 and by a guy named David Dudley Field, and by a strange coincidence, his brother Stephen Field was one of the first judges on the California Supreme Court. So maybe that's why we've been stuck with 6106 since 1851 when it was originally enacted, and the legislature shows no sign of getting rid of the BNP code. So we're going to have to live with that for the rest of my life certainly.
And David, you weren't even around in 1861, if I'm not mistaken.
But I was very young in 1861. Yes, I was just a kid.
Institutional knowledge often provides rationale. And knowing the rationale behind some of these rules might have prevented the misbehavior in Epic Games versus Apple. Because one of the things the court also said that David's comments remind me of is that the behavior violated the spirit of the order. It's not enough to say, oh, technical compliance, I really did comply. No, you knew the spirit of the order and you were in violation of that. And that doesn't, judges don't appreciate that, and it often serves as an aggravant because then it appears to be devious or malicious or an intentional attempt to circumvent what was clearly the intent of the judge issuing the order. So, thank you for reminding me about that. That's really important. And I'll tell you another rule that's really important here in California is good old 6068B. And for those of you that don't know that off the top of your head, that is the duty of respect to the court. And let me show you a little bit about the way that is phrased. Duty of an attorney to maintain the respect due to the courts. So if you ever find yourself traveling on vacation and you have forgotten literature to read, you don't have a magazine, pull up the annotations to 6068B. They read like a novel. You can't make this stuff up when you look at the kinds of case law that's been made by lawyers failing to show respect to court orders. It is absolutely unbelievable. But that's part of the analysis in a case like this is you've got to follow an order. There are ways to judge, there are ways to challenge a judge's order. You have to take one of those attempts at remedying the injustice if you believe the court was wrong instead of disobeying the order. Kind of like in my line of work, if you get arrested, you don't think you deserve it, you've got to go ahead and go through the process and then you challenge it. So too when it comes to failing to respond and obey a judge's order. And it's more than that. There are lots of cases that are just fascinating examples of colloquies caught on the record as to the kinds of things that lawyers do and say, thinking that well, I've made a record that I was about to disobey a judge's order because I found it to be unlawful, and then going ahead and disobeying the order. And the court just refers it to the state bar, and it's easy to prove. I mean, that would be the kind of case David would have loved to have had when he was a state bar prosecutor. It's a transcript of what transpired that was dishonest. But 6068 talks about that, and the case law and the annotations give some really good, clear examples that won't surprise a lot of people, but may surprise some that have a lingering belief that, well, it's the right thing to do for your client. If you know the court's wrong, the right thing to do for your client is not to get yourself in trouble now on top of the fact that your client's already litigating a matter in court. So this is one of the citations you'll have in your material. Now, this is interesting. Now, those of us that have been around for 30 years or more, nobody do the math, but some of us remember the old Business and Profession Code section 6068C. And I wish I was live with you guys because I can imagine some of you are nodding your head right about now. Do you remember the offensive personality proscription? I mean, what in the world did that mean? Who has an offensive personality? Many lawyers would say, "Yeah, that's why I win all my cases, is I'm really good in the courtroom. I'm a bulldog in
Yeah,
court."
yeah. Some lawyers would say, "Well, I'm a good lawyer because my personality is offensive." But it's this is nostalgic for me because as a prosecutor, I prosecuted a lawyer for under this rule. This was a lawyer but his behavior was really extreme. He would lose his temper and throw chairs during one of those old-fashioned in the room depositions. He'd get mad and pick up a chair, kind of like Bobby Knight. He was like the Bobby Knight of personal injury lawyers. He'd pick up a chair and throw it across the room in the deposition when he got mad. And so I prosecuted him early in my career under this rule. And a few years later, the Ninth Circuit said unconstitutionally vague.
What was the result
Offensive
of your case?
personality.
What
Hmm?
was the result of your case? Did you win?
Yeah, the public approval. It was minor discipline, but still, it was something, and it was under the old version of 668F. I think we could agree that throwing a chair across a room is offensive personality. But that's we had that tool back then, and but the truth is, if the state bar wants to prosecute a lawyer, they will find a way to do it. But that was a convenient way to do it then.
And what's interesting about that comment, David, is a convenient way to do it is also by looking at recent case law, judges' orders, and decisional law. You
Right.
sort of get a feel for, well, what are the courts consider to be dishonest behavior nowadays? And there was a time when not every lawyer believed that failing to follow completely and to the T a court's order would get them into trouble or get them disciplined. Now we even have these nuances as to, well, maybe technically you followed my order or most of my order, but you did it in a fashion that you knew would give yourself another option of finding another way of doing what I said you couldn't do, which is also part of the Epic Games versus Apple ruling. So it's just interesting, and this is the case that we normally cite for abrogating that rule. But it's almost like if any of you have raised teenagers, there come to be those years where they're smart enough to know how to technically be in compliance with what you told them they had to do or they couldn't do, but still managed to misbehave. And what do you say in response unless you're a lawyer? Well, the spirit of the rule wasn't followed. You may have followed my word. I mean, that's what the lawyers were doing in this case, arguably. There's two sides to every argument, but that was the argument here. And that's what the argument is in plenty of other cases like Epic Games versus Apple, where the court makes a ruling and the lawyers find creative ways to continue making profit, continue doing whatever it was they were doing. Speaking to the media, by the way, is another place in which we've seen very high profile failing to follow court orders, whether it's a gag order, whether it's a limited gag order, but there are always creative ways to circumvent a judge's ruling, even when a lawyer does understand exactly why that ruling was in place. All
Just
right. Yeah, please.
Karen, just a quick comment on the offensive personality. We have a lot of there's case law being made all the time, and of course, there's a lot of discussion. The judges are very upset about the decline of civility, and there are certain civility measures that are still pending in the Supreme Court. Actually, they've been pending for 2 years now, so it's interesting that Supreme Court has not acted upon them. But the last point is, and we may have a slide on this down the road. The what are the one of the things that exist in tension with that duty of respect to the court is the fact that a lawyer still has First Amendment rights. Even in the courtroom, to an extent, a lawyer still has First Amendment rights to free speech. And in the recent case law from the state park court, where lawyers have engaged in various kinds of questionable speech, the court has done a very adroit job of maneuvering between the duty of respect to the court and the lawyer's First Amendment right to criticize a judge, because you do have a First Amendment right to criticize a judge. Now, but there are nuances. That right doesn't extend to making threats against the judge's family. We had a recent case in the state park court where the lawyer was making threats. Threats are not covered, but legitimate criticism can be protected by the First Amendment. And that is sometimes in the heat of battle, lawyers forget where the line is.
And that's a good point. 8.2, the rule that talks about what lawyers can say about judges, really talks about dishonesty. And it's an interesting point you bring up. It's kind of the reverse here is that we can't say anything that's dishonest, made in bad faith. And by the way, stay tuned. Several of these rules were out for public comment recently regarding potential updates. And that goes back to what we said at the beginning is these rules are living beings. They are being updated as issues arise and as ethical issues get litigated in court. And then you have rulings like this. Now, when I say like this, I mean ordering a criminal referral. And I show you by example, violating 6060 AD in court, messing with opposing counsel's papers during a court recess, hiding things. I mean, this sounds pretty bad, doesn't it? 60 days suspension. You would think that it would have been more serious. And I feel like we've seen cases since then that have been more serious. And Epic Games versus Apple is one of them, when now you're actually also talking about potential referrals for criminal contempt. Now, I mentioned 8.2 because I knew this slide was coming up next. That has been another way in which a lawyer's statements have been analyzed when it comes to honesty, which is the topic of today. This is a case from Arizona, and where David just explained to me they're in monsoon season last week, I guess, despite it normally being really dry and hot. This is a case where a lawyer brought a motion for an honest and honorable court and made statements about the judge, such as dishonorable, brainless coward. But look at this. Now, this is not a try this at home moment. But it is interesting that the court said, well, that's not really 8.2a because who really knows what a brainless coward means? Dishonorable is a little closer, but some of the litigation that's been successful in prosecuting lawyers have included the word dishonest. And part of that has to do with the insinuation that a term like that used it to describe a judge. Basically, it means you're basing it on undisclosed facts, and there's something in there on the record that he or she did. However, the rulings go on, and this is just an example of the kinds of rulings that hold this kind of result. There may be terms that are ambiguous, kind of like offensive personality was maybe unconstitutionally vague, but there are other ethics codes that are going to get you making statements like this. And they give the example of 8.4D, which of course is misconduct. 3.5, we'll go through some of those, and they're in your materials also. And even 4.4A, which has to do with the way you treat another party. There's no substantial purpose in making comments like that under 4.4A other than to embarrass and burden judges. This comes up in so many different ways, from calling a judge by his or her first name to making statements loudly in the hallway and in the earshot of other litigants about to go into the courtroom. There's a lot of that goes on in the heat of the moment when lawyers lose their tempers. But what really gets them into the most trouble is when it is also insinuating that a judge is dishonest. The same thing that judges expect from lawyers.
I think the result in California would have been different under California case law than the Arizona case. I suspect that that lawyer would have been disciplined in California for making
Yeah,
those statements
more than he was.
in pleadings. Apparently he didn't. Arizona was forgiving for whatever reason, but that would not fly in California, in my view.
And look at this explanation that was given, that given but not accepted. The medical defense was not accepted. And, even if a court thinks, well, maybe actions are not 100% intentional, they were knowing more culpable than negligence. And that's another thing that we have done in California when we amended our rules. We talk about the negligence standard differently in the way the rules are phrased. That's true both in competence 1.1 and in diligence 1.3. So keep an eye on those. They talk about gross negligence, not plain negligence. And I always say, my legal advice, don't be the test case. because you never know how a different state bar judge, maybe you won't get a prosecutor like David. Maybe you'll have somebody else that's arguing the subtlety of why we have the rule and why we have those distinctions. And if there's conduct engaged in that circumvents a court order, like we had in Epic Games, that might be something that is going to be found to be knowing. So that's kind of an example of how that might come out in California. All right. So one of the things we'll move into just briefly, and you'll be able to see these in your materials, but I wanted to point out comment 4, since we've been on the topic of both what you say and how you say it. The decorum of the courtroom rule. Now, why am I showing the ABA rule? Because we don't have a perfect counterpart here in California, which is one of the reasons for Rule 1.0 comment 4 is we're invited to look elsewhere for guidance since we don't have anything explicit here. But many judges will tell you, and David and I frequently co present with judges. Anytime we start talking about contempt, the judge will get ready to interject because what are they going to say? They're going to say, for the record, a contempt is a last resort. We as judges do not run around holding litigants in contempt. It is a last resort. We might threaten it, we might discuss it, but we're not going to do it unless we have enough to back it up. Another reason this case was so significant. But look at comment 4 under ABA Rule 3.5. Doesn't it sound a lot like the old offensive personality standard? It also calls up these civility standards that we all know and love that have been promulgated in our jurisdictions. Refraining from abusive or obstreperous conduct. Don't you love that word? It just rolls off your tongue. Obstreperous conduct is a corollary of our right to speak on behalf of our clients. So it's sometimes interesting and certainly informative to read about what is expected in the courtroom if we don't already know instinctively. It goes back to some lawyers thinking, I'm paid to be a zealous advocate, and that's exactly what I'm going to do. And without my edge, I might not win every argument. Well, without your edge, you probably stand a lot more likelihood of never being afoul of any of these ethics rules because more and more they're sure beginning to look like they're incorporating the mandate of civility in addition to ethics.
Well, that's the tension in the law between the duty and the Z word is sometimes mentioned among ethics lawyers. The Z word is zealous. And the idea that zealous, you can be zealous, but you can't be a zealot. In other words, you have to you can advocate vigorously for your client within the bounds of the law. That's Justice Holmes' famous formulation. And that ought to be always the picture I always had of that is, well, you can go 100 miles an hour, but then you got to be prepared to stop on a dime. And some lawyers can't stop on a dime, and they cross the line from being a zealous advocate to being an obstreperous zealot. Because as a matter of human nature, it's knowing the line is difficult, and that's our job as lawyers is always to know where the line is, always to know where the line is. We don't always fulfill that role very well.
And by the way, if you, in a heat of passion, drive right over that line, you can make it better for yourself by engaging what case law declares is the post outburst purge. In other words, you apologize immediately. You don't wait for a court to make a ruling and hold you in contempt. You get up there right ahead of it and you do everything you can to mitigate it. That it was said in the heat of passion, you lost your temper. It's not going to happen again. Lawyers have really saved themselves much more pain and heartache down the line by acknowledging guilt early. And that's encapsulated in this comment as well. Look at what it says. It says you're protecting the record for subsequent review and you're preserving professional integrity. Here we get a lot more colorful too. They talk about that's a better tactic than engaging in belligerence or theatrics. Don't you love it? I mean, they really thought this through in describing, no doubt, some of what then seen in the courtroom in trying to give us some good guidance that that's not what they're going to expect to see from you. Now, this is an interesting part of comment 4, isn't it? Here we go, turning the tables again. If you have a judge that is engaging, so you believe, in behavior that perhaps violates their canons of judicial ethics, your remedy is not joining them in their misbehavior. Look at what it says. stand firm against abuse. You avoid reciprocation of the judge's default. Let it be no justification, listen to this, for similar dereliction by an advocate. So there's no excuse here under the law if, well, he started it. Nope. You would be in violation of 3.5, even if that in fact was the case and you had a record to prove it. All right. And there again, we talked about throwing chairs at depositions. Here you go again. That duty to refrain, and David, this would go to the chair throwing example.
Yes,
Disruptive
absolutely.
conduct. They talk about more than dishonesty, disruptive conduct. So you can imagine that's a very broad swath. You probably can imagine witnessing lots of things that happen in the courtroom as being disruptive. But there again, that is just not in a regular traditional courtroom. That also includes a deposition.
Just a
Okay.
word on just last a comment on the ABA model rules. Um, the ABA model rules, I mean, I spent a lot of time pondering the differences, and every state's enacted a different version of the model rules. But California's is very, very different than the ABA model rules. But in terms of concepts, the ABA model rules and the comments are much more extensive. You have a very long preamble to the ABA model rules, which is worth reading. Now, they're not the law in California, but they can be extremely valuable, and I've certainly used them in my work as a defense lawyer in discipline cases. I certainly use the concepts of the ABA model rules for persuasion as opposed to them being black letter rules of law. So if you study the ABA model rules in law school, more power to you. Um, you didn't waste your time. Now, that doesn't mean you can't know the California rules too. So I would say to California lawyers, you may have studied the model rules in law school, but you got to read the California rules because they're much, much, much different.
Yeah. We talk about the Code of Civil Procedure and the court's power, and you'll have those in your materials. But I want to follow up on something that David said about, kind of the difference in California and the ABA. We have measures and statements and comment sections in our rules that implicate the division of responsibility, the allocation of authority between you and your client. Obviously, when it comes to the goals of litigation, the goals of filing a case. The client has a lot of sway there, but not when it comes to defining how it's going to be accomplished ethically. And that is where you have what I'm going to turn it over to David to talk about. Another one of my favorite rules is, the issue of client communication and the way in which you are an advisor of sorts. And that goes not only with meritorious claims and contentions, which is something that you're going to have to decide, but it's also going to talk about a couple more rules, and then we're going to turn it over for questions. So this is one section, but I really want David to talk about this rule. And I think it's so important. I broke it up into two slides for him because this is a really important rule that many lawyers have never actually read and considered in its entirety. I frequently hear lawyers saying, well, that consideration isn't really appropriate for me to discuss with my client. I'm really only paid to do legal analysis. Well, maybe no, you're not. Maybe your role is broader than that. David, what do you think?
Well, this is what they call you. I've heard things like this referred to as Easter eggs. This rule is an Easter egg. It's hidden in plain sight. It's not. No one's, to my knowledge, has ever been prosecuted, at least in California, for violating this rule. But this rule goes to the essence, the absolute essence of what it is to be a lawyer. A lawyer. I'm sorry, Epic Games. I'm sorry, Apple. Uh, but you're not a hired gun. You're not a mindless robot that takes direction from the client and win at all costs. You are a officer of the court. It's not in this role, but you see it elsewhere. It's clear the judges think you're an officer of the court, but you have a duty to exercise independent professional judgment and render candid advice. And shockingly, this means that sometimes you have to say, no, client, no, you can't do that. Or no, client, I won't do that. And in in the case law and in the rules, you'll see plenty of examples. Rule 1.2 is a good one here as well, talking about the roles of attorney and client. You're not a robot. You're not a hired gun. You are a officer of the court. You're a quasi-governmental official, which sounds crazy in a world where lawyering has gone business mad. What motivated the lawyers for Apple? Well, money. I mean, let's be honest. That's what it's all about in high stakes litigation, right? Money. But you're still someone obligated to exercise independent judgment. And um, a lawyer may initiate advice to a client when doing so appears to be in the client's interest. In other words, you can even go outside the scope of the thing that you've been hired to do to say, don't do it. This reflects a vision of lawyering that dates from the time when when lawyers were not service providers. We didn't provide a commodity, but we had a relationship with our clients. So you might say, well, this is a little bit anachronistic. Maybe it is. But in my view, this is what the essence of lawyering, of professional lawyering is all about, the exercise of independent judgment. And I think it's important to keep this light burning. Keep this bring out this Easter egg from under wraps.
That's great. And what's interesting also about 2.1 is this last section here. Many times I've heard lawyers say, well, I can't talk about politics and religion. I mean, but look at what it says in comment two. It doesn't prevent a lawyer who renders advice from considering things like moral, economic, social, political factors if it's relevant to the client's situation. I mean, it's a fascinating rule, like David said, that's been hiding there in plain sight. It's always been there. I've always thought it was fascinating, and you just don't hear about it. But some lawyers have found it to be enormously valuable to sort of read the room, read the jurisdiction, know what arguments will and won't be persuasive in a certain area on certain facts of your case. Is it a rural jurisdiction, a red state, a blue state? I mean, there are so many factors that may allow you and behoove your client to be able to talk about some of those factors that are just non-legal. And by the way, in terms of the advice that you're giving and the case that you're representing, David mentioned 1.2, which is allocation of authority. 1.2 even says that you may not buy into all the arguments you're making to be able to make them. In other words, you may be representing a client in a matter that personally wouldn't be the way you would resolve the matter. And so 1.2, 2.1, some of these sleeper rules, as we say, are really valuable in today's legal climate. Now we are reaching the end of the hour, so what I'm going to do is take a little peek in the. I don't see the Q&A. I see the chat. That's just
Yeah, the
programming.
Q. I see the Q&A.
Okay. Maybe I
Want me to read the question? When?
only if it's one that one of us can answer. You take.
Well, this. Well, we only have a few questions, so I think we can at least take a stab at them.
Sounds
First
good.
question says, what happens when the judge's directives, minute orders, and orders are unclear? What do you do then?
Yeah, that happens all the time. Dave and I can both give our answers on this. That happens a lot of the time in my practice because I'm in court every day. And, we seek clarification all the time. Oftentimes we have the luxury of a court reporter. So they may get a read back of what they said and figure out themselves how they maybe can rephrase it. But it's never really been an excuse to, especially if it's an unreasonable interpretation of an order to claim, well, that's what you said. And I would imagine that would go back to again what we saw in Epic Games versus Apple is that everybody knew that the remedy and the rationale behind the remedy, the injunction, the order, and that finding another way to make money off platform was the last thing they should have done given the boundaries of the order. But I'll give David a chance to answer this. It's a great question.
Well, again, you have to play, in some sense, the cards you're dealt. You have opportunities to ask the court for a clarification, perhaps in the courtroom while the order is being made. You have the opportunity to seek reconsideration. You have the ability to appeal. All of those may be imperfect remedies. It may be very difficult to understand the court's orders. They may be ambiguous, but you have to do your best to try to get clarification so that everybody knows what the judge is ordering the litigants to do. And there's no perfect answer to that because judges are human like everybody else. And sometimes what they do is not clear.
Well,
Yeah.
preface it with too, and by the way, everybody take a screenshot. That's our contact information. You can preface it, and I've done this a lot, is preface it with, if I may ask for some clarification because I want to make absolutely sure I understand the boundaries, the scope, the breadth of the court's order so I don't violate it. You make a record like that, what's the state bar going to do? They're gonna come after a lawyer like that. You've done everything you can to understand the clarification. You're seeking clarification because you want to make sure you understand. And that's always going to save you. And guess what? Judges love to hear that kind of a question because they're going to be even more sure that if you do something accidentally, that it wasn't intentional because you took the time to seek that kind of clarification.
Well,
So
and making the records the kind of courteous, patient, uh, zeal advocacy that the role talks about. And when I do it, I always say, "Thank you, Judge. Thank you, Judge, for allowing me to make a record," in my most polite, diplomatic way, to sort of make it clear to the judge that thank you for thank you for being part of a constructive part of the process. And making record is really something a judge can't. I've actually there have been instances where the judge said, "No, I'm not going to let you make a record." I won't tell you what court and what county that was in, but it's one you may know well in California. But it does happen, but you do your best. The second question, and it's a good one, is the judge obligated to report CCP 128.5 sanctions based on lying and intentional suppression of information? I think that the question is the judge obligated to report that to the state bar? And as I read the statutes, I think the question is yes. The Office of Chief Trial Counsel actively solicits the judge's cooperation. They send letters to the judges on a regular basis and say, "Tell us what's going on in your courtroom." Sometimes judges don't want to report a lawyer to the state bar. They don't want to be a snitch. But the Office of Chief Trial Counsel, in their zealous way, encourages judges to keep the state bar informed about misconduct. So I think you have to assume the answer is yes.
and we're gonna have to defer the rest in case you want to email both of us offline. And I'd like to thank David for joining me on this program. I mean, that just terrific. So you've gotten two
You
perspectives,
ending.
a number of fresh, timely issues that no doubt are just the beginning of courts really taking a hard line as to the ways in which they expect compliance with the orders that they make. So with that, I'm going to turn it back over to our presenters, and I want to thank everybody for being on the call today.
Thank you, everyone. It's been fun.
Thank you.